Hi, good morning. Mark Martinez from the law offices of Mark Martinez. And today we're going to talk about quiet title lawsuits. Quiet title, as a real estate attorney here practicing in Southern California, we deal with a lot of quiet title lawsuits, and quiet title is just a fancy name for a type of lawsuit that could help you in a number of ways to remedy problems with a residential real property in California. This is a comprehensive statutory scheme. That means there's a set of laws about this in the California Code of Civil Procedure starting at 760.010. And you look that up on the internet and you're likely to find all the laws and the chapter that governs this. And quiet title is something that could be used to defend against a potential wrongful foreclosure. Let's say you've lost your house and you were foreclosed on, you believe improperly. A good cause of action to put on there would be quiet title and allege that you are the rightful owner of the property, even though it's in another individual's name. It is an uphill climb, but that can be done. It also is a good tool in a lawsuit to have when you have the property transferred between individuals that really never bought the property. So nothing is stopping anyone from transferring title to a property. I could transfer my property to my son if I wanted to my sister, to you. That doesn't mean that you bought it from me. It means that you're on title. And if I wanted to do anything, I would need to get your permission. And so a lot of individuals find themselves in this situation where they need the cooperation of somebody else who's on title and they're just not getting it. And a quiet title could potentially be an appropriate cause of action. If there's any clouds on title, defects, maybe there's a loan that shouldn't be there, a reconveyance should have been recorded and it wasn't, quiet title lawsuit can clear that up. Maybe somehow there's another individual on title from a previous transfer that was never cleared. This lawsuit could request that the court take care of that and make a ruling. The procedural part of quiet title, this is something that is typically an equitable cause of action versus a legal cause of action. And equitable cause of action is a fancy word, again, a term of art that just means that more than likely the judge is going to be deciding this rather than a jury. There are a few cases where a jury could potentially decide a quiet title lawsuit, but for the most part, it's going to be a judge sitting in equity based on principles of fairness. And so the judge will decide based on all the evidence that you tell him, the story that you present, along with the evidence and testimony about who he believes should prevail in regards to the real property in dispute, the title in dispute. Some of the other procedural considerations is there needs to be a verified complaint. And that means that the plaintiff needs to sign the actual complaint under oath. And the defendant needs to respond with a verified answer, which means that they need to sign their response, which is typically not done in other lawsuits. Also, there's a request for a preliminary title report or a litigation guarantee that goes back and takes a look at the title so the court can see who the previous owners were, how title was passed throughout the last 24 months, things like that. And the other portion is a litigation guarantee, which is similar to a title report, but it's a title company basically stating, we allege this is how title was passed, and it's just a little bit tighter as far as cleaning the title up. A lis pendens is recorded on title, and a lis pendens just broadcasts to the world that there is a current lawsuit. This makes it very difficult for the current title holder to transfer the property while the lawsuit is pending. And And then also it coincides with what quiet title does, which is a lawsuit against known and unknown individuals. And so a lis pendens gives constructive notice to the world that there's a lawsuit being decided. And if anybody has any potential ownership interest, this is a way where they can request to join into the lawsuit. And the lis pendens also broadcast judgment against everybody. So it's just a cleaner way of deciding the quiet title lawsuit. I hope this helps, and best of luck to you in this situation. If you are looking to file a quiet title lawsuit, or be defended in a quiet title lawsuit, I definitely would recommend attorney representation. These lawsuits, civil lawsuits, are very difficult to navigate by your own. So look in your local directory for an attorney. Thank you.